Hello, good afternoon. Hello, everybody. Oh, thank you so much. Is it cereal? Oh, thank you so much. I appreciate that. Happy to be here. Happy to help where I can, if at all. Hopefully, it helps somebody somewhere somehow. So hello, welcome in, everyone. We're kind of doing a throwback today. Oh, from Florida, my goodness. Hello, Nikki. Hello, hi, Kristen. Good to see you as always. Hello. Well, welcome, Teas Oasis. I'm kind of throwing it back a little bit today over our little lunch and learn. I used to do a set of lives where I would just clear off my desk. So I would go through and just show everybody what documents that I'm, hoarding that I haven't been able to get to because it's just been too busy. And I have so many. So this gives you a chance to kind of screenshot any of these cases if you want, or if you're interested in doing a little homework on your own. That's up to you, but just to make sure this information is very valuable, and I've not been able to get it out, but I just don't have the time to dig into it. Or afternoon, exactly. So that's what I was hoping to do today, to go through. I've just got this big stack here. Big stack. So I've got case names and where they're at and what's going on with them and stuff. So you can just kind of pick and choose. I'll just do a very brief overview here. And not enough Post-its, true story. Hello, Doughboy. So, right. And I just don't have time to do full lives on all of these. I will be coming back and doing some lives on a couple of them, but I just don't have enough time for everything. I know. What do we have? Yes, so we're going to have a stack of miscellaneous here. This is called Let's Clean the Desk Off, all right? Love your nails. Oh, thank you so much. Consumer protection. Yeah, that's a big one. Ooh, that's a big one. Yes. That's on my list. My to-do list. Oh, thank you so much. Thank you, everybody. I do have a couple of cases I definitely will be going and doing lives on. The consumer protection situation is a big one. Let me make sure here. I don't have it at my fingertips. And we also have another lawsuit against FEMA for how they have mishandled the Texas situation. So I will be going through that as well. But for this little lunch and learn, we're just going to clear off my table here. Precedent via shadow docket. Oh, I know, Doughboy. It's been kind of ridiculous. How often do you go live? I try to go live as often as possible. Tuesday nights, you can always catch me over on the tube unless I have to cancel. But I do have a Subscribers Sunday where everyone can hang out, but I just have the comments set to subscribers. Other than that, I just try to come on whenever I can. So many lawsuits, so little time. True story. Oh my goodness. The executive order around the involuntary institutionalization. I've not yet. Did that one just come out? Well, hello, Nani. Good to see you. Let me just see if I can put this in here. Oh, thank you. That's kind of a weird area of the law that's not been friendly to women, especially. So we got to kind of keep our eye on that so it doesn't get, it's kind of a gray area that was never taken care of properly. So, okay, let me just look here. If this is the homeless keys, right? Ooh, okay. Yeah, I see it. So the ACLU's involved, forcible hospitalization for homeless people. Oh, EGADS. We don't like that. That's awful. Hold on here a second. I'm just peeking. Executive order could increase hospitalization of homeless individuals with mental health and substance use disorders. Now, lest we forget, we also have had the Supreme Court come in recently and not necessarily helpful for, I believe it was in California, the homeless population, some of the homeless population there. So we don't have a lot of empathy here. find ways to make it easier to forcibly hospitalize homeless people with mental illness and addiction for longer periods. An effort to fight what the administration calls vagrancy threatening the streets of the U.S. All right, well, just even with just that information, it's congressionally set. The Congress decides how long people go in for it. I mean, that's how the law is written. So if you want to write a law and pass a law to put them in for a longer period, you go through Congress. So there's that. So we gotta just make sure. Was it Oregon? We gotta just make sure that we're keeping an eye on it. But at this point, it doesn't look like there's going to be anything that can be done. Actually, any actions that can be done. So we gotta remember that. Number one, we look and see what crazy has happened. Number two, we look and see if there's even an implementation possibility. So that way we keep some of our sanity as we go through this. People are unable to take care of themselves. I know, it's rough. That's a yikes. DHS using IRS data to track us all down and keep us, well, right. And no, I'm not a big fan, as many of you would know at this point, but, I'm not sure how much they weren't using that before, honestly. So yeah, the wording's critical. All right, so here we go. Again, everyone, we're doing this quick and dirty today. I'm just going through what I've got on my desk here. The first one here, again, and I'll just put it so you can do, if you're interested in the case, just do a screenshot and then you can look it up yourself. We have this case here, 1, 2, 3, 4, 5, 6, 7, 8. Okay, so this is the situation where we had 8 people pulled and put on a plane and sent to South Sudan, all right? And in the interim, there was a filing by their attorneys stating you did not follow what was required of you. So you didn't follow the notice requirements. And also you didn't follow the are you in fear question thing. And we do that because of the understanding we've got with the UN, right? So these were not followed. They filed a suit, obviously, and then the judge said, well, you need to go and talk to them. And because they stopped the planes in Djibouti, which is where they have been hanging out, and the judge said you need to go to them and ask them these questions about, their fear of the torture in order to be in compliance with CAT, which is a UN requirement. So they did that, but then the Supreme Court was like, whatever, you don't have to do that. This level of notice wasn't actually required here. And so, we've been dodging ever since. But if you're interested in the case where it's involving those 8 people, I've gone through this on a live before, and where they talk about the extensive criminal records of all of these men. And they do. And we're not talking just traffic stops. We're talking actual valid criminal records where some of them have spent some time in prison. Some of them have been deported multiple times. So this is not a great group of people here. These are some bad people. I feel comfortable saying that. But at the end of the day, even bad people get due process, right? So that's this case. If you're wondering, you want to keep an eye on it. We've got the court number here, the case number here, and then which is easy to find if you're interested in that case, okay? Yeah, needed to go a long time ago. Exactly. And this should have, if they had just done it through the proper channels, then there wouldn't have been any questions. And that's one of the things that frustrates me so much is that, it's not like I'm in here saying, well, let's go hug trees and everybody's great. No, in fact, the opposite. All right, don't touch the tree because you don't know what's on it, first of all. And second of all, no, people aren't, good. People aren't inherently good. But what I will say is you still got to follow the rules. Rules are rules. You got to follow them. You can't get around them just by trying to dodge responsibilities. This is a situation where some bad people needed to have due process in order to keep them out of the community. And that due process was not done. So that's a problem. All right. So there's our first one here. Again, hello, everybody. I am just kind of going through my desk here. going through this stack of papers to give myself a little bit of a break because I've got so much. I've got so much. All right, next one. Next one up. We've got July 23rd, and this is the order denying the petition to unseal the grand jury transcripts. Oh, this is the JE case. I'm not sure I can actually say that word. That could get me into some trouble. So we'll just call it the JE situation. All right. Here. So this was the order that actually came down here saying the request to unseal the grand jury transcripts has been denied, which I think is a good call. Now, some people might say we're entitled to all of that information, and I get it. But our standards of proof of the grand jury are different than our standards of proof in a trial. So even though that's interesting information and helpful for a grand jury to come to an indictment and helpful for both parties to see what evidence is available, it's not necessarily as helpful for the public because you're not seeing exactly how that evidence is credible or not credible, right? So we don't have a jury, a fact finder saying, you know, this document's good, but this one's bad, or this conversation is relevant, but this one's not. Or, you know, this photo is good, but this one's obviously been doctored. Like, we don't have a regular jury to make those determinations on the authenticity of the evidence. So it's kind of a problem because we don't have any defendants in there. This is just the prosecutor, and they're bringing stuff in and nobody's objecting to it. So when you release transcripts for juries and such and those kinds of things, if we're at a grand jury level, I worry that the evidence won't come out the proper way so that the public would understand what it is, because it really takes you know, the rules of evidence to kind of filter out what's not good. And I won't sit here and tell you for 1 minute that all evidence is valid. Absolutely not. Every piece of evidence needs to be authenticated and used properly in a grand jury situation. They just have different rules here. So yeah, so I don't want to say this person's name, but this is the request that I believe it was the president that actually made to unseal those grand jury transcripts. Although I could be wrong. I reserve the right to be wrong here. But they said, nope, we're not going to do that. So that's the next one. Let's see what else we have here. Oh my gosh, everybody, seriously, I'm just clearing my desk off. I used to do these all the time. Like once or twice a week, I would just come in and go through my paperwork. All right, here we go. So we have plaintiff's opposition for defendant's motion for a stay pending appeal. This is the Slaughter v. T-Rump case. Let me see. No factual dispute here. Immediate summary judgment. Let's see. Oh, the law and removal of the FTC commissioners clear. So this looks like we had that an elimination of somebody's position. And so they're saying, we don't even need to have a trial. We don't need to have anything going on. We just need a summary judgment. So this is a petition. This is not a ruling from the court. So this was just filed a couple days ago here. All right. So if you're interested in that case, again, this is a lawsuit against the administration. Looks like a firing of someone here, removing people as the FTC commissioners. So that's going to be a big case here. Did SCOTUS grant cert? Don't know right now. All right, so that's that case, everyone. All right, flipping through. Let's get the next one out. Oh my gosh, I just have too many things here. The Slaughter case was answered. Okay, great. They would have had to have answered that pretty quick. Was it the Supreme Court that answered that? Again, as I try to go through my case here, find what to read. Come up quick for some news. All right, sure. Now, give me a second. You know, it takes me a minute to get myself sorted here, Dave. So hold on. All right, here we go. Hopefully I'll do this correctly. It's anybody's guess. Here we go. Let me see if I can do it. Okay, here we go. Oh, did we make it? Are you there?
Yes, I am. Good
Yay!
evening
Hello.
or
It's been
good
too
day.
long. How are you doing?
Yeah, I'm good. I'm good. No, another case for you to review with the class when you have a moment, if you haven't heard about it. The DOJ sued New York City yesterday. They sued New York City regarding regarding New York City's sanctuary city status, or their
Oh,
laws regarding sanctuary cities. So they're going to be challenging the whole sanctuary city idea. Basically, my take on it, it's going to be supremacy clause versus the 10th Amendment, states' rights versus the supremacy clause.
right, right. And we do have a couple of other cases where they've done that.
I think they threatened to do it to Lexington, Kentucky, and then Lexington backed down. But I
I
don't
was
know if
thinking of
they've ever
the
gone through.
I was thinking of the Minnesota one.
I didn't know about Minnesota.
Yeah, yeah. I don't think it's gone very far, but yeah, I
Hmm.
mean, oh my goodness gracious. Come on.
Hey, they're going to do it. Look, you want to know? I mean, truthfully, in this particular case, in order to be ideologically consistent, I side with the Justice Department on this one. I'm sorry. No, I'll tell you why. So, ideologically consistent. I believe that everyone in the country should have the same rights. This is
Hmm.
why the whole that the not Obergefell. What is it? The case that overthrew Roe. I forgot the name.
Dobbs.
Ah, yeah, Dobbs irks me so much. The idea that a woman in Kentucky has less rights than a woman in Virginia and the two states share a border, that pisses me off.
Hmm.
I
Hmm.
understand it's the law, it still pisses me off. We should have the same rights and obligations for everyone in the country. It shouldn't matter where in the United States you live. It's called United States. But
Hmm.
here you have municipalities and states who have taken it upon themselves to create extra rights, or at least to not cooperate with the federal government regarding the federal government's enforcement of its rightful power over immigration.
Hmm.
So, I
Hmm.
mean, to be ideologically consistent, I stand with the DOJ on this. I believe in federalism. If I was around in 1789, I would be a Hamiltonian, not a Jeffersonian. Put it to you that way.
Hmm. Hmm. Fair, fair. And by the way, as a
Yeah.
quick side note, I was just thinking as you were walking through that, the Minnesota case is actually about in-state tuition.
Oh,
and
oh,
whether and
interesting.
whether right and whether or not certain people can be given in-state tuition pricing even though they're not from the country.
Now so the federal government wants to step in on how state universities, not federal universities, state
Right.
universities, that's a little bit, now,
It's,
again, ugh, I thought these are the people of small government.
I know, right? Oh my gosh.
Yeah. Yeah. Anyway, that's all I wanted to tell you because I know you love doing this stuff, and I think that's when it's going to be big. It's going
Oh
to be
yes.
big and ugly.
Well, I'm going to put it on the closet. This is going to be a big
Yeah.
one.
Oh,
Well, thanks for telling me.
also, no problem. Also, yesterday, this is great. I don't know if this is really right up your alley, but President Macron, I think he's
Hmm.
president. Yeah, yeah, French is suing Candace Owens for defamation of his wife.
Yes, I have that in my stack. It's
Yeah,
like
that was
200
good.
pages.
Yeah, that's going to be big. That is going
That's
to
going
be.
to be
That's going to be.
fun.
It's going to be another Fox News, except she is not a corporation, and they're going after her personally. They are going to
Right.
sink her. She's going to be paying out money until like she's 92.
It's going to be crazy. And I'm like here
Yeah,
for it.
me too. Me too. All right, take care. Just wanted to update you.
Thank you very much. You too. Always good
Bye.
to
Love the
chat.
nails, by the
Bye.
way. Love the nails.
Thanks. All right. Well, that's great info. Good to know. And I think our only other sanctuary city case, now that I'm thinking about it, everybody, is San Francisco. I think that was the other one. Sometimes I get my cases mixed up. But I think San Fran is the other sanctuary. We do have two cases. Again, the Minnesota case, and I'm trying to remember the other state. Minnesota, and then there's a red state, actually. I'm not sure which one, where they're talking about tuition. So that's a little different animal as well. So we've got that going on. Right, right. Oh, yeah, I've got that case out. It's a lot. It's a lot. All right, here we go. Lightning round. This one, a memorandum and opinion here, and this is the FBI agents who had worked on the January 6th investigations. All right, so they were suing to stop the Federal Bureau of Investigation, so the FBI, from disclosing agents' personal identifying information and retaliating against them in violation of the First Amendment. Fast forward to the end, right? Because that's where we're at. The foregoing reasons, which I have not gone through, the court grants defendant's motion to dismiss for lack of subject matter jurisdiction. This case is therefore dismissed without prejudice. Plaintiff's motion for temporary restraining order, which the court had previously deferred, and the motion for preliminary injunction are denied. Again, so this is one of the cases where it's just been straight up kicked out of court here for subject matter jurisdiction. And I do want to spend some more time going through this. I'm going to put this in the pile to do on the lives. Well, let me ask you all, would you be interested in me doing a live on this? This would be a great one. A great way to make sure I'm getting the cases out to everybody. Should we do a full briefing on this one? This is, again, the FBI agents who worked on the J6. Okay. We got to, sure. All right, then. All right. This one was fast. Yeah, there's a lot. Okay. So I'm going to just put, okay. Yes. Okay. I'm going to just put an orange flag on it. That will remind me to prep this. So I'll go through and annotate and then do a live on it. Now, when exactly, I just don't know. There's so many things going on. All right, next up, we're going to just keep flipping through. All right, next up, I've got the Haitian Evangelical Clergy Association. This is kind of like flashcards for me, like I'm trying to remember what all these cases are about. Hold on, what's this case about? Let me see. Conference here, letter here, another letter here. Their response. Okay. Summary judgment. Okay. So partial summary judgment was granted. Let me pull up the exact date here. Sometimes I just print out a couple of pages as a reminder to myself to go and read the full docket. So let's see what the docket says here. 0146. Oops. That's not 664. All right. Interference. Ooh. All right. Okay. Let's see. Usually it helps if I go back to the original complaint and I just look at the first couple paragraphs. A nation in chaos, past several years, violent whatevers. Here, circumstances from bad to worse, blah, 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 blah. Do the right. Put another way, blah, blah, blah. Wow. Or 10 paragraphs, apparently. Keep going. So repeats. Okay. So we've got TPS designation. Really? All right. Well, that's interesting. All right. So TPS, and this was a huge group too. So temporary protective status. And I believe the courts have set a later date. So it can't be done immediately. Let me just double check. We have here, the last filing was on the 23rd. Right. Okay. So asking to put aside a partial vacator as unlawful. And the court's saying you need to be more specific. And so they just filed a letter with the court. So it looks like we're kind of in a waiting pattern on this one. Right, and the court wanted to cancel the conference on the 22nd until they got more information. Stay until February. Okay. Sounds great. Now, until February. So they're pausing. We're on pause. Oh, no worries. We're just, going through cases. If you find one interesting, you can screenshot it and do a little homework if you're interested. You certainly don't have to. All right, what else is next? My goodness gracious. What do I have all in here? My goodness. Oh my gosh. All right. Petition for certiorari. I'm not ready to do that one yet. Oh yeah, we've got a case where we've got a partial mandamus granted. Mandamus is very rarely used, or it used to be before this administration. Mandamus is a writ that you ask the court to tell a government person to do something. All right. So you're commanding someone in a government position to do something. So this case is, let's see, this is in front of our District of Columbia Court of Appeals. And it looks like, let me see here, not appropriately tailored here, injury, blah, 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 and moving for summary disposition, withdrawn discovery requests that pertain to recommendations. All right, here, excluding those interrogatories and requests will narrow the district court's April 15th discovery order, right? Petitioner's arguments in opposition do not otherwise alter. All right, so let's see what happened then. The administrative stay entered on April 18th be dissolved and the motion for stay be dismissed as moot. Okay, so it looks like we're going forward on discovery in this case. All right, so that was kind of a long journey. Long journey, but looks like discovery is going to go forward even though the government had requested everything to be paused. Right, that's kind of anticlimactic. I'm not sure wonderful's the right word, but it's something. All right, next up we've got, this was yesterday here, consideration of plaintiff's consent, motion for scheduling. Oh, this is the lawsuit against the judges in Maryland. All right, so these are the Maryland judges case where the administration suing the judges, like the whole bench. Here, and we've got the court saying it's ordered, the motion's granted. So a motion for scheduling order and memorandum in support. So it's looking like they're trying to get things scheduled, and the judges the defendants are the judges, but the plaintiffs are saying, let's do that. Meanwhile, the plaintiffs shall file a combined reply in support of their motion for a preliminary injunction. So the preliminary injunction would be all of the Maryland judges would no longer be able to do their job, and a response to defendant's motion to dismiss no later than August 1st. So the judges have filed a motion to dismiss. And again, I don't think, we've got proper jurisdiction. I don't think you can just sue a bench full of judges. If there's some weird way that can happen, like that needs to be taken care of, because that's crazy town. So they're just saying here, we've got a response due by August 1st. And then after that response, then the defendants can file a reply. All right, so that's a quick update there. Oh, thanks, June Marie. So if you're interested in that Maryland judge case, here's the number right there. All right, fast forwarding now, and the Russell case. Let me see here what we've got going on. I'm literally just going through a stack of papers, everybody. So this is pretty low key here. Pretty low key. Wait a minute. Is that from, what year is that from? 1887? Oh my God. Oh, here it is. Okay, wait. Nope, that's not it. Oh, wait, maybe. Nope, that's not it. Okay, hold on here. Sorry, tangled up. Oh, this is the Marriage Act. All right, sorry, we're skipping Russell. We're skipping through Russell because that's not exciting enough for us. All right, let's just look real quick and see what Russell's about up here. Nature of the suit, statutory actions. Judges lose immunity. Yeah, I don't know. I don't know that they do. That's why it's like, why are you filing this? This is ridiculous. All right, well, I don't know what the Russell case is about. Truly, I can't remember. It's out of Maryland. All right, well, this is going to drive me crazy. Hold on a minute, everybody. I tried to let it go. I tried to put it in the done pile, and I just can't do it. I can't. I must know what Russell is. All right, hold on here. Okay, CV 02029. Okay. Right. Yeah, it's the entire bench. Scan it into AI or Gemini. Well, that's a good question. And I guess I was saying, several people have asked me about that. Can I put it into a spreadsheet, or could I put it online somehow? And all right, hold on here. Oh, this is the judge case. Okay. So this is the judge case. I missed his last name is Russell. There we go. Phew. I was gonna say that's weird. Why did I even have that there? The thing is, like I do this not just because it's fun, but I have I have some medical problems, honestly, and it prevents me from being able to use my computer in certain ways. So I can do a lookup, I can do something along those lines, but the reason I have to print it out is because I can't read it on the computer. So this is how I have to do it in order to be able to read it, which isn't great, but has helped other people because other people are like, well, we can't read either. And I'm like, all right, let's not read together. So we just kind of mix it up. But so things like emails and blogs, those kinds of things, I can't read them. I usually will print them out if it's an email that I think is important and have one of my children read it to me. So that's just kind of how the wind blows for me. All right, next up, Ermold Moore versus Kim Davis. Oh my gosh, everybody. All right here. This is, let me make sure I know what this is. I think this is Obergefell here. Let me just peek around here. This is the Obergefell. Okay, Obergefell alert, everybody. So Obergefell is the, no worries, Jean Marie. We all adapt, right? We all adapt. So the Obergefell case, right, that was decided in 2015 about marriage doesn't have to be between just a man and a woman, right? We remember that. So this woman, Miss Davis here, was involved in that case with David Ermold and Moore. So she has been in the court still. I feel so bad for these fellas because they are still arguing this in court. They are still arguing it. So she owes damages to them, right, for the wrong that she did, because at the end of the day, it's a lawsuit, right? So she owes them damages, and she also owes them attorney's fees. And so what she's been doing is tangling up the courts with multiple requests to try to get her accountability dispelled, basically. And she's been able to, well, I'm not sure she did it, but there's a group that has come in and said, we're so horrified by the Obergefell case, we will represent you for free. We will go forward on this case and help you. You don't have to pay us, but we want to get the Obergefell case in front of the Supreme Court again because, of who's on the Supreme Court, right? So I would say I was hesitant to go through and share this case. Here we go. Sorry. Because they have filed a writ for certiorari. I believe this was filed just a couple of days ago. Alliance Defending Freedom, is that right? Yeah, it's something kind of funky like that. I wasn't sure who it was here. Oh, Thomas. Oh, I know. You see, I know. Yikes. That could be right. Yeah, it's a religious organization. And so they came in and said, we'll come in and help you. So she wouldn't be able to do this without their help. So what has happened, right? So Miss Davis, she owes the people that she discriminated against some coin, all right? It's, I don't know, a couple $100,000. I say that like nonchalantly, but that's a heck of a lot of money. So she's come in and she said, like, there's all these reasons why I shouldn't have to pay that. So they have said, well, the district court's like, well, you have to pay it. Sorry, but you have to pay it. And she said, well, I have immunity because I am a government employee at the time all of this happened, right? And if you're a government employee, certain kinds of immunity will get triggered, right? The problem is she was a state government person, and that means that federal immunity piece is out. So the district court's like, you don't have immunity, you're a state person. And then the Court of Appeals is like, you don't have immunity, this is a state person. So that is one of the pieces, is this whole idea that she was immune to being sued because she was a government employee, and so she doesn't have to pay them any money. But then what's happened here? I'm not surprised about that. The piece of it that, we should be concerned about, again, I tread lightly here. I have no number here. I have no stamp. So I tread lightly because I don't have confirmation other than that this was available online and I've read through it, but I don't have any confirmation that this is truly going to be going forward. But one of the things I think that's important here, Let me make sure I have it. This is, hold on, everybody. I'll find it. Okay. I'm calling it the Wisco moment. So let me find it here. State marriage rights. Right. The proceedings, incarceration, quest, jury verdict award. Oh, I don't know where I found it. Hold on. Oh, here we go. Here we go. All right, here we go. So this is what I'm referring to as the Wisco moment, where it's saying this court should revisit and reverse Obergefell for the same reasons articulated in the Dobbs case. Dobbs is haunting us, everyone. Obergefell was wrong when it decided that it was wrong. Sorry, when it was decided, and it's wrong today because it's grounded entirely on the legal fiction of substantive due process. Can you even believe it? Don't tell Wisco, okay, everybody? But what? They're basically trying to overturn substantive due process. Liberty Counsel, thank you so much, upgrade. Yeah, I knew it was something like that. I know, right? So that's, I don't know if you can just come in and say, we want to have you reverse this case, Supreme Court, because, you were wrong. So what are they suing the Maryland judges under? You'll have to go in and track that down. I can't remember off the top of my head, forgive me, but basically there's some kind of bias involved is what they're saying. None of them are competent essentially to rule on any of Mr. T. Rump's cases because they're biased. They're being activist judges. Why have these people just let us be? Oh, I know, right? So again, everyone, I'm not going to do a full post on this because I do not have that corroboration on this case. It is in Court Listener. If you would like to pull the case up, and it's got, we've got decisions here from the district court, which was correct. And we also have the Court of Appeals here. So if you're looking for the case number, you can pull this up here. Again, this decision from the Court of Appeals is what they're appealing to the U.S. Supreme Court. Here's the number. It was just in March. So you can even believe it. I mean, that was done in 2015. And these guys are still wrapped up in this legal bologna sandwich still. I mean, it's like, what? It's like they were just waiting in order to bring the case again. And so that's unfortunate. Very frustrating. And I'll cover this if anything comes from it. But at this point, it's just so ridiculous that I don't want to spend too much time on it. All right, so that's that. Then moving on next. Ooh, here we go. This is the, goodness gracious. So this is the lawsuit that was filed against Mr. Kennedy in his capacity as the Secretary of the Department of Health and Human Services. All right. So, Taylor. All right. Yeah, take care, man. We can do it. I got you back. We can get through this stuff. So one thing here, we've got a complaint for declaratory and injunctive relief. So we've got the American Academy of Pediatrics, American College of Physicians, American Public Health Association, Infectious Diseases Society, and then Massachusetts Public Health here, and Alliance Society for Maternal Fetal Medicine and Jane Doe. So this was the case that I was it was really sweet. I was invited in to hang out and work on a panel and talk about these kinds of things. So some of the information regarding the vid of the 19, if you know what I'm saying, that information is being pulled, and they're also not doing recommendations for infants or for, I'm sorry, it's not infants. It's anyone up to the age of 17. So that includes everybody and mothers. All right. So they're not giving any of that information out anymore, or those recommendations. Now, the medical community, as you can see here, is like, what the are you doing? So they sued because they're like, you're causing some significant harm to our profession because we rely on the federal government's recommendations for child immunizations, for which ones need to be when and how we go about doing it, and to make sure that everybody's protected. So they're like, dude, you're screwing this stuff up. And so this was the complaint that was just filed not very long ago. Oh, I know. So dangerous. And there's another case. Hold on here. Let me get through all of this. What? No, that's not it. Nope, not that one. Nope, also not that one. Jeepers creepers. All right, just a second, everybody. I'm gonna get it if it's the last thing I do here. I'm swimming through paperwork. Wait, no, not Stromberg. What was the case? Yikes. Nope, that's not it either. Hold on. Nope, not. Hold on here. That's not right. Did I miss it? I think it's Jacobson. I need the Jacobson case here. Blah, blah. Just a second. This is so important that I am pausing right now to search through to find this so I can share this with everybody because this is really important to me, apparently, here. Hold on. Nope, those aren't. Nope, that's not right. Nope. No, and where did that go? Is it at the bottom of the stack? Let me see here. Okay. Oops. Nope, that's not right. Okay, no. Candace. Oh, there's the Candace case. Okay, we'll get to that in a minute here. Let me see here. I gotta get it, or I'm just gonna lose my brain. Oh, here it is. Okay, phew. I know I have it in here. This is a very important case. Ugh. All right, thanks everybody for bearing with me here. There we go. Oh my gosh, that was more than that needed to be, but alas, here we are. All right, so here's the case, everybody. Oh my gosh. All right, hold on. I don't know what's going on here. Just a minute. Oh yes, thank you. I do have a Venmo if anyone is needing, interested in donating to my Post-it fund and paper fund. So here we go, everyone. This is the case I wanted to share that I really would like to make as homework for people. Anyone that's interested in this whole idea of the childhood immunization. So that's like a really big whoop-de-doo-dah. And if you are interested in going down that road and you're like, well, how's this even happening? We have this case, Jacobson v. Massachusetts here, and it is 197 U.S., which means it's Supreme Court, and then, I don't know, 11, I guess. But you can just pull up Jacobson v. Massachusetts, and there's one piece in this case that is so incredibly important. And it's right here. The liberty secured by the Constitution of the United States does not import an absolute right in each person to be at all times, in all circumstances, wholly freed from restraint, nor is it an element in such liberty that one person or a minority of persons residing in any community and enjoying the benefits of its local government should have power to dominate the majority when supported in their action by the authority of the state. So this is a very powerful piece here. And what they're saying is, we understand if you don't want to have those, immunizations going on, but for the best interest of society, it's allowable. So this was the case that was brought up a lot during the mandatory vid stuff that was going on during that period of time. This is like the gold, the gold, I keep saying gold bar. Is it gold bar standard or gold star? I can't even remember. This is the case, everybody. It's not been overruled. It's been dinged a little bit. But if you're interested in doing some research on that, and you want to know how that works, I recommend the Jacobson case out of Massachusetts. So that's what I was digging for. And then I found it. And so gold standard. So it's not gold star or gold bars. Golden Graham. Oh, I like that one, Jason. Let's use that one. Golden Graham. I don't know, everybody. Look, my brain does its own thing sometimes. It's like, what? We're going to do this. All right. Since I pulled that case, let me just pull this for screenshots if anyone's interested. This is the Wong Kim Ark case. Now, this is the one establishing birthright citizenship. This is the case, but then, of course, we also have federal law that also sets out birthright citizenship. So this is the judge law here, and this is the congressional law here. So if you're interested in this particular case, there is the citations there if you would choose to look it up. It is kind of a sad story, though. I'll just say that. He never was able to enjoy the benefits of citizenship because of how all of this went down. And it's a sad story, but he's an amazing person to keep pushing it. All right. So there's that, and then Stromberg. I don't want to go through Stromberg with everybody here. Hold on. Let me see. What's this case? This is the red flag case, all right, that I had gone through a while back for anyone who may or may not remember. This is the case out of California, and this was in the 30s when we have the, it's just awful. Oh my gosh, we're so racist, everyone. I mean, just acknowledge it. So the Chinese Exclusion Act was one of the pieces that we had to deal with, and that has to deal with Wong Kim Ark. But another piece of that same kind of discrimination was the California did this. California Penal Code, Section 403A, had set out a law that said you cannot display a red flag in public in a meeting place. I mean, in California, this really happened. So here's the rule itself. You condemns displaying a red flag in a public place or in a meeting place, A, as a sign, symbol, or emblem of opposition to organized government, or B, as an invitation or stimulus to anarchistic action, or C, as an aid to propaganda that is of a seditious character. I mean, what are you doing? So that's crazy town. And the Supreme Court's like, nope, we're not going to do that. But that's the red flag case. That's why I would say I don't think any state is exempt from making bad choices. I think that's something for everybody to remember. You know, if you make a bad choice, recognize it, fix it, and move forward in your life. All right, so if you're interested in this case, Stromberg v. California, and that's the red flag case here. All right. Again, for those of you just joining, I'm just clearing off my desk here. I'm just going through my stacks of paperwork. Oh my gosh, because I have so much. All right, next up here, this is American Oversight versus Hegseth. Ooh, what's this one about? Motion for preliminary injunction. File status report setting forth the steps they have to comply. All right, agency head shall notify acting archivist Rubio of the signal chats. What? Backing it up. All right, let's back this up here. All right, pursuant to the court's June 20th order, granting in part and denying in part the plaintiff's motion for preliminary injunction, so that's American Oversight, defendants filed this status report setting forth the steps they've taken to comply with that order. The order requires, 1, that agency head defendants shall promptly notify acting archivist Rubio of any signal chats of which they are aware that contain federal records at risk of impending deletion, and 2, acting archivist Rubio shall promptly request the Attorney General to initiate an action for recovery or other redress to preserve any at-risk federal records in such chats and notify the Congress when such a request has been made. So they're just setting, yes, Signalgate. So they're setting out what the order was. So here's the defendant's response. Defendants through counsel have each confirmed that they are not aware of any signal chats of agency head defendants containing federal records at risk for impending deletion. Specifically, the agency head defendants or their staff communicated that existing signal chats of which they're aware federal records are not currently set for automatic deletion or have been preserved through other means. Accordingly, in the absence of any known federal records at risk of imminent deletion, the predicate for notification under 44 U.S. Code 3106 sub A is lacking. And we have it assigned here. Elizabeth Shapiro. I don't know if I've heard of that one. This one I've heard. This one I'm not sure I've heard of yet. All right, so there you go, Signalgate. If you're wanting to follow this case, this is the case number here. It is available on Court Listener. This is document 38, so it's got some traction already in the courts. All right, yeah, I'm just going through my paperwork here, everybody. All right, here's another one. Just to remind everybody, I do plan to do a full piece on this one. This is the Loper Bright Enterprises case. A lot of people may be like, what's this whole Chevron doctrine stuff? And this was such a huge case. So the Chevron doctrine we're using basically every single day. Because why? Because we're dealing with the Administrative Procedure Act against the administration. We're saying you are violating the APA over and over and over and over again, right? So anytime the AP is involved in something, Chevron's going to be close behind. So I think you need more cases, Murray. I'm not sure if Rubio is the archivist. Isn't that weird? Because I'm not sure. The Constitution sets out that you can't have too many jobs at once. So I'm not sure how that's going down. But anyway, this is the Loper Bright case. I will be doing a full live on this at some point. It's huge. And the Chevron doctrine was very simply, if there's some ambiguity in language in a statute, they would ask for the experts basically to come in and be like, well, what's this mean? And then that would be the standard that they would use. Now they came in and said, no, you got to go to court instead. You can't just ask the experts. You got to ask the court. So basically just making everything so much more difficult and taking a lot more time. Because why? Well, because in court, you're going to call the experts and you're going to ask them, what do you think? And they're going to tell you, and then that's what you're going to do. The only thing here that's different is now the courts are involved in that. So that's the case here. Yeah, Kelly, huge bogging down. But several of the cases already involving this administration, I think again we're at like 325, have already pulled in the Chevron doctrine. We call it the Chevron doctrine due to a case that established the doctrine, but it's actually the Loper Bright case that overturned the Chevron doctrine. All right, so that's that. So that happened. Next, Barbara versus Mr. T. Rump here. And we have an order granting a preliminary injunction and provisional class certification. So this is where we have the birthright citizenship case that was answered by the Supreme Court regarding injunctions. So they're like, well, if we're going to do nationwide injunctions, you have to have different set of factors. This case doesn't meet those factors. So what they did then is they took everybody and applied them into a requested class. So this is the class action lawsuit for any child born after February 18th are to be now included in this class action. So this was another way of covering that birthright citizenship executive order. So the Barbara case is covering all of the babies, and then the case that I went through yesterday is covering all of the states. So basically all of the pieces now, all of the people are being covered through either this case or the other case that I went through yesterday. So the case for yesterday involved United States-wide injunction. They said, we do have the factors, we're meeting them all. So that's fine. And then the Barbara case covers any infants. Everybody follow me on that one? All right, next up, Refugee and Immigrant Center for Education and Legal Services versus Noam. We do have an appeal that was filed here. A joint status is due actually today. I don't see what the status report is. Let me just double check real quick and see what our status report is. And I know I'm kind of all over the place, everybody, but it's just we got a lot, and I think it's okay to just do little sound bites. Sometimes we don't need a full-on 3-hour lecture on it. I think it's okay to just kind of smack it and move on. You know what I'm saying? All right, joint status report. Hold on a minute here. In light of the status report, the court, this is just today. Just today, we have a joint status report that has been filed. Let me take a look at it here. You're doing great. Oh, thanks, Willie B. I appreciate it. All right. Court granted plaintiff's motion for summary judgment. Right. And class certification. Right. Court deferred to the ruling on the remaining portions of the parties' cross motions. Ordered the parties to submit a joint status report on or before the 11th. Fast forwarding. Court granted that request. Court ordered parties to do a further report. This is your report, people. Seriously. The defendant's stay motion remains pending in the DC Circuit with briefing complete as of July 10th. At this time, the parties agree that briefing on deferred issues should remain in abeyance, so they're paused. As previously proposed, the parties agreed to submit a subsequent status report August 8th. So they're paused. They're waiting for more stuff to happen with other cases. So we're on pause. That wasn't that exciting. I think that could be more exciting. All right, Center for Taxpayer Rights versus the IRS. This was late June. Unopposed motion for modification of the briefing schedule. So I think this is just for my closet docket there. Yeah, and then Amica Center for Immigrant Rights. Oh yeah, this one I'm going to definitely do a full live on. This case was dismissed by the courts. A full dismissal. Now, it wasn't dismissed with prejudice, but this is it's a very important case. Let me just take you through this first paragraph here. Plaintiffs in this case are 12 nonprofit legal services organizations. Many years plaintiffs served as government subcontractors for 5 federal programs that provided legal services to individuals in immigration proceedings. As subcontractors, plaintiffs provided free legal orientations to non-citizens, advising them of their rights and duties as they navigated the immigration system, among other services. The programs were paid for and administered by the Department of Justice's Executive Office of Immigration Review, pursuant to its annual congressional appropriations, which included an earmark for a portion of the programs. Rather than provide legal orientation services itself, however, EOIR historically outsourced the program's implementation to one prime contractor, which in turn subcontracted with the other organizations, like the plaintiffs. So they've recently decided, however, to terminate its prime contract to administer the programs, leading that prime contractor to terminate its subcontracts with the plaintiffs. So we have another issue here where they are dismantling another piece here and pulling funds for it. So I will do a full live on this one because I think that's important here. There are a couple of legal issues going on in there that I think are interesting, so we'll take a look. Here we go. I don't know if I want to do this one. We'll see. New Jersey versus Mr. T. Rump. Let's see what the issue is here. Oh, my goodness gracious. So much going on. Oh, thank you so much, Kelly. Oh, I appreciate that. I need a little something extra today. These days are getting a little bit bonkers. All right, hold on. I made a note to myself. Good for me. All right, states must obtain complete relief. Right. Oh, this is the one we went through yesterday. Nationwide injunction to get complete relief. So we all know how that went down. This was a response and opposition. So this was filed before the order that I read through yesterday. So if you're interested in that nationwide injunction case, this is the case number here. If you want to go look that up for homework, because, we don't need homework, but for fun. All right, here. Now this case, oh my goodness, everybody. I'm definitely going to be doing a full live on this one as well. Just one second. I'm just double checking my stuff here. Okay, so this state of Washington. Oh my gosh, this case, everybody. Oh my goodness gracious. All right, state of Washington. This was just on the 23rd, so 2 days ago. Oh yeah, Murray. True. And honestly, Biden had quite a few lawsuits. All right, I think. Okay, so it was Trump that had this huge number of lawsuits in his first term, and then Biden had a whole bunch of lawsuits. Like maybe people don't recognize or realize that he was being sued constantly, by certain groups of people. And then now with this second administration, it's like blown all of those numbers out of the water. Like you'd have to combine multiple presidents' lawsuits in order to hit the number. And we're 6 months in, right? So, this is absolutely bonkers. We're in bonkers town. So this is a lawsuit brought here for a Federal Emergency Management Agency. So we've got our FEMA lawsuit going on here. July 16th is when it was filed. And it's filed by Massachusetts, Josh Shapiro, State of Arizona, State of California, State of Colorado, State of Connecticut, Delaware, Illinois, Maine, Maryland, Michigan, Minnesota, New Jersey, New York, North Carolina, Oregon. Here. Oh yeah, they're paying for all of it. They're paying for all of it for sure. Rhode Island, Vermont, Washington, Wisconsin. So all of these states are involved in this. Now, there's no Texas here, but these other states are saying, wow, we don't want this to happen if we have troubles too. So they're trying to get ahead of it by filing this kind of a lawsuit. All right, and then I've got this one. Everyone, we know about this one. This just came out June 27th. This is the CASA case, where again, the universal injunctions, the court said, no, you can't do them in this case, Mr. CASA, but it may be appropriate in other cases. What other cases? Well, we don't know. And we're not going to tell you because that's just how we are. And then there was kind of a couple of side notes here on, but class action lawsuits would be perfect here to do the same thing, but, you know, with a different name. So that's that. And then this is also what set out the format that they were using in the other case, the New Jersey case, in order to say that nationwide injunction was okay, again, for birthright citizenship, because this time they actually satisfied all the factors. All right, and then here we go. We've got the Perdomo v. Noam case. So we've got a plaintiff's ex parte applications for temporary restraining order and orders to show cause regarding preliminary injunction here. This is the Los Angeles case that I've been walking everybody through, where we've got excessive force and inhabitable conditions or inhumane conditions when they are pulling people and detaining them. So if you're interested in following that case, this is the number here, and it's the Perdomo case. And there are quite a few people actually involved here. Et al. Means and others. So we've got several people that had injuries, and I think, I think we've got, oh my goodness gracious. So, right, so this is how they broke it down for those that may remember that. We had 7 counts, and we've got violations here of what laws had been violated, who had been involved, and then the defendants over here. So that's another, oh, I hope they win too. So this is another case here if you're interested. And then, let me see here. We're kind of coming down here to the finish line. Oh, Trophy Dulce. Oh, that's another really important case. Sorry, everybody. I'm literally drowning in my paperwork right now. Blub, 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 blub. No, paperwork. All right. Sorry. Justice Black, Justice Douglas, Justice Whitaker. Citizenship is not subject to the general powers of the national government and therefore cannot be divested in the exercise of those powers. And even if citizenship could be divested in the exercise of some governmental power, it violates the 8th Amendment because it is penal in nature and prescribes a cruel and unusual punishment. So this case is old school, and it has to do with someone who was sentenced, and part of his sentencing was they withdrew his citizenship. All right, citizenship here. And the court's like, well, no, you can't do that. And this case is so good because it really sets out a lot of the foundational pieces when it comes to citizenship. But in this particular case, this fella was in the military. I mean, what was the 1958, so I don't know, it was maybe during the Second World War, and he was stationed in Casablanca, and he was like, I want out, so he hopped the fence and ran away, and they chased him. They're like, you're in the military, you can't just run away like that, that's against the rules. So they caught him, brought him back, court-martialed him, kicked him out of the military, sentenced him to some jail time, which he did, and then a few years later, he tried to take a vacation, and they said your passport's not valid because you're not a citizen anymore. And he said, well, what? Nobody told me about that. And then we have the Trope v. Dulles case, where the court came in and said you may not use withdrawing citizenship as a punishment because it would violate the 8th Amendment. So very important case, incredibly important here. So, you know, that's why I'm sharing it. If anyone wants a little homework here, there you go, the Trope case. And then let's finish up. Well, I guess I've got a little bit of the JE case here. All right, I've got two we can take a peek at here quick. This is the indictment of this fella right here in the violations of the law that was involved. And of course, we look here and we see that this is a federal violation. And we have federal law being charged because, of course, it has to do with moving people around or asportation when it comes to like kidnapping and such. So that was involved here. Hold on, I've got two pieces connected. I'm like, wait a minute, that's not right. So here's this indictment. Oh, I guess I just printed one page. So if you're interested in looking up this case and going back and looking and seeing what was charged here, you can pull this case up here. And I think this is, yeah, so this should be appropriate. This is, appropriate for finding information on it. So you can screenshot that if you're interested. Here, I've not spent a lot of time on that. I did, if anyone is wanting to really track some information down, I would recommend, I wonder if there's statements in here. Let me see here. ADHD's all over the place. Oh, I do have it. Hold on a second, everybody. I would recommend, there's a lawsuit filed against Mr. T. Rump and Mr. J.E. For bad behavior from both of them. And the case is called Doe v. Mr. T. Rump and Mr. J.E. So they were sued together for harm. And if you go and look through the civil case, the information is still available on what happened and what was said and such. But we have two statements included under a pseudonym, which I thought were very interesting. They have specific pieces where certain people's names are actually used in that declaration, which again, a declaration is a sworn statement to the court. Here we go. And then here we go. We've got another mention of that. So for anyone saying, well, blah, 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 like here it is right here, court documents right here, quite disturbing. So again, I won't be reading these out loud, but if you're looking for that kind of information, you can find it. You can look it up here by pulling this. Oh, that case number is not very clear, is it? Hold on, let me see if I can find the full case number. Oh, here it is. Oh, good for me for finding that. Sometimes you got to pat yourself on the back. Here's the lawsuit. It was dismissed ultimately because Miss Doe ran out of funds. She ran out of funds and couldn't pay to keep this lawsuit going. So the case was pulled. But there's a lot of very interesting information that is out that's available because our rules of evidence are a bit different in civil court versus criminal court. So some of the information that's available in this particular case is not going to be able to be available in the other one. Maxwell witness tampering. Good question, Kelly, and I'm not sure. I'm not really sure. I'm not sure how appropriate it is for an attorney in the DOJ to go in and talk with someone who's been sentenced. Just, for funsies. So, if they're not investigating a case, it's like, what are you doing? Right. It's public record. Yeah, could be. All right. And then here's the last piece, everybody, as you hang on for dear life as we go sailing through the ADHD. Oh my gosh, situation. So this is a complaint filed by Macron. All right, and Brigitte Macron. So husband and wife, a team out of France. I don't know. I don't know what the relationship is, but they're married. So I don't know if you're married, are you part of a team? I'm not sure, but I'm calling them that. This is a huge complaint. This complaint is enormous. The minutia of details in here. This is absolutely, we don't do that in this country. We don't put this level of detail into our complaints. I suppose we can, but typically we don't. Our judges would get mad at us. But the detail here, and you can tell that, it's not like they're filing lawsuits in the US all the time. They certainly are not doing that. So they wanted to make sure that they had covered everything. And this complaint, I would like to go through it at some point, but this would be an amazing, oh my gosh. Come on. This would be a great example to show people details good, but too much details unnecessary at this point. I know, right? Oh, it is. It's really, Anyway, so you can't just say whatever you want, as we all know, but apparently some people think they can. If they're popular enough, they can just say whatever they want, whenever they want, and not have any consequences. And that's just not always true. Right, right. I don't really know who she is that much. I don't know why, but for some reason, if she comes on, I block her out mentally. So people have tried to tell me about her world, but for some reason, my brain's like, nope, I'm not going to do that. We're not going to do that. So that's that. Oh, final piece. I suppose we can just put this up here real quick. So this is the last piece would be the Abrego Garcia case. This is the criminal court in Tennessee coming out and saying you can be released. And then we have at the end of this one, oh, maybe I don't. Well, and then there's another one out of Maryland, I believe, where that judge says too, you're free to go, but the cubes can't come after you immediately. And then we had a double request out of Tennessee from the defendants and the plaintiffs asking for him to be allowed to stay. So he wants to stay, according to his attorneys. He wants to stay where he's at for now, for the next 30 days, and the court granted that. Yeah. Oh my gosh, Big Grandma, we're at like 325. We're at there's a lot. There's really a lot. We're about to say June he's released. Oh, absolutely. Absolutely. I mean, and rightfully so, because there's a lot of weird stuff going on. And honestly, until they find the 4 missing people and the UN gives us a report on that, I would say it's anybody's guess about what's going to happen to other people right now. I normally wouldn't say that, but in this situation, I think there's enough probable cause to be a bit worried about that. Katie Johnson testimony? I'm not sure. I've gone through so many cases. Oh, no worries, Big Grandma. No, this just happened in the last couple of days. No, you're not behind. You're not behind. Nope, it's just all happening so fast. That's why I was like, let's just do the Tower of Paperwork today. Executive order preventing dual citizenship. Not yet, Murray, but that is one of the pieces of P25, right? To take that dual citizenship away. I'm not sure how that would actually work without Congress. I don't think it can work, actually. Another situation where Congress has set out statutes and those laws have to be followed. Again, the president doesn't make law. The president can put in procedures, administrative procedures, essentially, but cannot make law. And that's another thing that's absolutely crazy with the birthright citizenship case, is that, you can't just come in and say, well, 14th Amendment. Nope, it doesn't work that way. Like, they don't even have the job of interpreting the 14th Amendment. Like, they're already way beyond. They're like, well, this is what these words mean. Like, you don't have the authority to say what those words mean, actually. So, calm down a little bit. International adoptees, right. Dual citizenship, yeah. Well, it's something, again, they're trying to go after in P25. I don't know how they would actually accomplish that. But then again, I mean, there's crazy stuff going on. Crazy town. Like, they're trying to get, football teams to change their names? Or is it baseball? I don't know. Somebody's supposed to change their name. Then, like, the View's all worried they're going to get canceled. And, like, Colbert's leaving. This is crazy madness town. So we're all struggling a little bit with that. He's a breaker, not a maker. Oh my gosh, that's perfection, Carol. That's so true. Oh my gosh, it's so true. NFL and really. Okay, interesting. South Park makes it bearable. I don't know, everybody. I've seen little clips here and there, but I had to stop watching South Park because it was just like it was really gross. So I used to watch it all the time, but it's like, man, you're too far. You're taking this too far. Like, I want to laugh, but that's gross. It's not funny. But now I'm like, oh, maybe I should watch it. But I'm worried that I'm still going to be like, not sure. I stand with Colbert. I know, me too. Oh my gosh. He hinted at perhaps running back in his state, so. Group of people singing in support. Oh yeah, I mean, come on, we adore him. He's been here through thickness and through. I feel like he is a spouse to us, right? The episode is perfection. All right, all right. Well, I don't know. I don't know. I think there was like a movie that came out, not, that came out. And then after I saw the movie, I was like, I'm done. That's it. I'm all done. They did a sorry statement. Oh my gosh. Maybe I'll watch that. I'll watch that one. Oh, thanks, Rose Cheek. Oh, you're so sweet. Yeah, I'll have to double check and see. I knew what you meant, Bay Grandma. I knew what you meant. We were simpatico there. Oh, could be picked up by another network. Exactly right. He is, I know, right? He's an extra, he's a spare. But he's so talented. The other thing too, though, is like, how far away is he though from retirement? That's the other thing you have to think about. Like he's put in the work. He has done the time and he's amazing at it. And he's been doing it for so long. So perhaps if he wants to walk away, that's up to him. But being forced out isn't appropriate in my opinion. Oh yeah. Yeah. And there was some talk, right, about Melania her name being put on something, right? Whatever. I mean, all of that stuff can be undone. I just like scraping off all that, gold bits and bobs that are in the Oval Office. Like you can just scrape all that stuff off. It's not too difficult. I'll do it. I'll volunteer. Just for anyone out there in 3 years, let me know if you need some help removing the gold bits. I'll help you with that. Yeah, 61. I know, Carol, right? Oh, I know. Love to see him and Jon Stewart partner again. I was so thankful when Jon Stewart came back to the Daily Show. I mean, it's only once a week, but it's like the medicine I didn't know I needed. Let me just tune in here for a minute. That would be very interesting. Oh my gosh, that would be a huge moneymaker too. Like, take my money, guys. Make a t-shirt, take my money. For sure. Absolutely. I'm waiting for the Cubes to pick up Melania. Yeah. Well, they're going to have to make it through your Secret Service, right? They're just plastic spray painted gold. Exactly, Willie B. I think that is like the perfect summation of Mr. T. Rump himself. It's like plastic spray painted gold. Yeah, we're gonna have to get some sage in there. Do that. Did they cancel a show? The show, I don't know about that. I don't know about that piece, but he's out. And I kept thinking too, like, how protected is he? I think after the George Stephanopoulos situation occurred, as soon as that occurred, I was like, oh crap, everybody, no one's safe here. So you gotta kind of, stay off the radar, keep your head down as best as you can, which is just like goes against what we all believe in this country, but not much you can do in that situation other than try to find something funny, right? That's what we're trying to do with the wildfires. Oh my gosh, that's the best. Like, listen, we got some wildfires going on over here. We're smudging. We gotta get rid of the negative energy here. Oh, tea break. Thank you very much. And here's my tea. Oh, thanks, Jordan. Thanks so much. Oh my goodness gracious. That was so funny. All right, my friends. Well, oh no. With that, I will go ahead and let you all go now that I need to put all my paperwork back. Thanks for coming in, hanging out. This was kind of like our lightning round, what's been going on, just to go through and remind everything. We got a lot of stuff going on. If it's not right in front of our face, sometimes we forget about it, but it's still there. And there are people behind the curtain who are watching and making sure that things are not falling through the cracks. So burn the furniture. Oh dear. Just make sure you're in a proper zone, right? Oh my goodness. So have a great rest of your day, everybody. I will definitely be back on Sunday. I'm not sure if I will be on or off throughout the next 48 hours as per usual, so forgive me. But I will absolutely be back by Sunday. So take care, everybody. Thanks again for coming and hanging out. I appreciate all of you. Have a good rest of your day.